Hello, everyone. My name is John Cartier. I'm an attorney here, and also I'm one of the members of the congregation at Horizons. So thanks for joining us today, and really excited to go through some of the basics here on wills and the state's trusts, and just general planning for the future, your family's future. Just do we have a clicker by chance, or for the? Yeah, okay, cool. Okay, sounds good. Thanks, Derek.
Just go click to it.
Yeah, I'll wave over there and select clicker. Cool. So just real quick on the agenda, the basics we'll go through here. First question, why plan in the state of Nebraska? What's the benefits there? Going into then wills, what's the difference between a simple versus a complex, and then the execution requirements of wills. We'll also go over what a holographic will is, which I guess could be considered a simple one. Third, trusts, when and why to use them. Cover briefly power of attorney, financial and healthcare decisions that come with that. Living wills, which is different from power of attorney, but they're related in what you need to do in terms of planning for the next stage of your life. Non-probate transfers and probate pass, and then finally just a brief checklist and common pitfalls. So number one, why plan in a state here in Nebraska? And this comes up in my own family because we have yet to get our will in place, which is, as my wife likes to remind me, something we really need to do. And of course, I'm an attorney, so we should have already had that done. But I mean, in general, it's a good idea because eventually all of us are going to pass. We're going to leave certain assets, certain property, and certain things behind for our families. And no matter what, it's going to go through the probate process, but you really want to have those specific directions that say, who's getting what. And that is going to help alleviate any conflicts within the family. And, I'm originally from outside Nebraska, but I came and moved here in 2010. And the one thing I've noticed is the thing that tends to really tear apart families here, especially, in an agriculture context, is when the dad and mom dies and leaves a considerable estate behind, and then all the siblings are fighting. And I've seen several families go through this and really just split them apart. And it's a tragic thing to watch. So as much as you can prevent that from happening is going to be a good idea for your family. Um, the Some other things like it will speed up the probate process, so it's going to move through court quicker. If you're falling into a bracket where you need to worry about the Nebraska's inheritance tax on a county level, that's something where really experienced estate planner can help you maybe avoid some of those costs at the end. Next, to certainly protect any minors, special need beneficiaries, and trusts, and as I kind of stated, business and farm transitions. And the final point, planning for any incapacity of the power of attorney and health directive. So this, I mean, really a comprehensive overview of the end of life stage, the things you need in place to protect your family, protect your wishes. Those are all good reasons why you should have an estate. So next, going on to wills, what are they? So real brief, will is essentially a written set of instructions for assets that's going to go through the probate process. After death, the will be filed with the court, and a personal representative will carry out the plan. Think of the will basically as just your set of instructions for the court, what they're supposed to do in probate. Who gets what needs to be done if it remains, who's going to cover the costs, all those really important questions. Next slide. Okay, so next difference between simple and complex wills. So in Nebraska, simple wills work when an estate is really straightforward. There's no tax exposure. There's clean beneficiary choices. So maybe it's just one or two children that are going to get the majority of the estates. Complex wills are for blended families, special needs planning, farm or business succession, or anything that doesn't really fit a simple pattern. They're going to have a lot more complex, language and provisions in them that you won't necessarily have in just like a boilerplate simple will. Um, the complex wills as well, like, yeah, I just completely recommend, no matter what your situation is just connecting with an experienced estate planner, making sure that they know, like, okay, we can do a simple boilerplate, simple will, that should be sufficient. Or, if you have like those specific instructions, and make sure, I mean, whatever you want, come prepared to ask for that. And, attorney will tell you, no, that's ridiculous. We can't, write that into it. Or they'll say, yeah, absolutely. And you can get very creative with the language that you put in complex wills that will, help give you and your family what you need. Next slide. So the requirements for executing a will in Nebraska. Number one, we need two adult witnesses present. Avoid it being beneficiaries. You want to have someone that's basically, not an interested party in the state itself. The maker testator declares the document as their last will and testament in their handwriting. You'll affirm that you'll affirm that the document you were acting voluntarily, you had free and sound mind to make these decisions, that there was no one who was coercing you into a will. Sometimes, I mean, these cases do come up occasionally where there's a family member or maybe someone else outside of the family who during the last couple of months of someone's life really goes in and shakes up a will in a significant way. And sometimes we'll completely write out other family members. If there's any inkling of cognitive decline or anything that can suggest that these people are taking advantage of the person, of the deceased, then you might be presented at that point with some court challenges, and you want to, of course, probate. You want to avoid that at all costs. You want to make this simple, clean, easy process. The other provision, self-proving affidavit recommended. Just another piece of paperwork that will continue to help simplify the probate process. And then, okay, on the next slide. So there's one exception here. There's something called holographic handwritten wills. So if you have and this can be on something like a piece of napkin paper, but I wouldn't recommend that. As long as it's completely written in the testator's handwriting, dated and signed by the testator, shows their clear intent. So on a piece of napkin saying, I leave my entire estate to my son Bobby. They can write that on a piece of paper, they can sign their name, and then you could actually present that for the probate process and use that as the document that's going to, basically be the simple or complex will. But this is not the preferred method by any means, but it is, an option based on Nebraska statutes. And not every state has something like this. So just something important to mention. Sure. Yeah. Last thing on this is just keep it practical. These are basically a last resort. So if you're in a situation where you don't have a will in place, maybe you got seriously sick or hurt or injured, you're in the hospital, you can't get access to a lawyer. This could be a potential option. Okay, next moving on to trusts. What are they? So trust is a written agreement where a trustee manages assets for beneficiaries. Trust can operate during life and after death, usually without court supervision. These are a lot more flexible than wills and can manage assets over time, not just distribute them all at once. Of course, this also really depends on who's going to be the trustee and if they're following everything that they need to do. A lot of times a trustee will just be like paid family lawyer who's handling these types of things. I've seen trustees who are other family members, and oftentimes those family members will let things fall through the cracks with certain filings that are required, as well as just maintenance of the trust itself. So when you're considering having a trust, really put a lot of thought into who's going to be that trustee, because ultimately, that's going to make or break what you're going to want and be able to expect from a trust helping your family move forward. Common trust types. So, and the golden standard is always going to be irrevocable trust. The other ones, though, testamentary trust, created in a will, revocable living trust. These can be changed or revoked by the grantor. The irrevocable trust, and I'll just mention real quick, when I was a law clerk for the Nebraska Department of Revenue, and one of my assignments was just going through like 200 or 300 various cases where there's taxes that have been owed and we're trying to get it from folks. A lot of the instances where there's taxes owed, we knew we we were supposed to have claim to those, but they're behind an irrevocable trust. And that is one of the hardest things to be able to pierce, even as the government, to try and get resources or assets out of that. So if you're considering a trust type, irrevocable trust, talk to your attorney about that, if that's going to be a good situation. But those, in my experience, seem pretty foolproof in a lot of instances and provide a lot of protection for families. And there's was a statute on there at the in this presentation. You'll see some statutes reference. I'll direct you to where a lot of the stuff's written down. I won't repeat exact words, but give you a good idea of what you can expect.
And irrevocable trust be amended, or once they're written, that's it.
That's a really good question. Probably a Matt question. Can an irrevocable trust, when it's after it's written and it's been executed and it's in place, can that be amended in any way?
Yeah, generally an irrevocable trust means an irrevocable trust would mean that you no longer have control over it. So unless you put amendment provisions in the trust, then no, you can't change it short of a court order. And it's very difficult for a court to change an irrevocable trust, because the court will be looking at what did the person who made the trust want to do, and is that in line with what the trust was intended for. So extremely difficult to change an irrevocable trust. So,
going back a few slides, you said that part of your choosing between the simple will, the complex will, was whether you hit certain tax thresholds. Is somebody going to cover kind of in general terms what those dollar figures are for those tax thresholds?
Yeah.
Okay.
Yeah.
Okay, cool. Thank you.
Okay, so obviously the first question you should ask if you're considering a trust is, do you need a trust? And you would need one in instances. For one, privacy is a huge factor. So if there's certain things that a family wants to hold on to and not necessarily advertise it, trusts are a good way to do that, especially if you want to avoid a probate matter. If you want to have a minor or other beneficiaries where you want to control what they're spending, how much they're spending when they get disbursements, that's another good consideration. If there's like farm property within the family and they want to continue to use that income to help pay for the trust and beneficiaries, that's another good instance where a trust would probably be a better idea than just selling the family farm and making a big distribution to everyone all at once. But not everyone needs one. Your goals and asset mix will drive this decision primarily. So again, once you sit down with a expert probate, wills, estates, and trust attorney such as Matt, he'll be able to guide you into those decisions and make sure you're educated for that choice. Next, talking about non-probate transfers. So essentially, for here, many assets will pass outside of the will. Things like life insurance, retirement accounts by beneficiary forms, transfer on death for bank and brokerage accounts, transfer on death deeds for real estate in Nebraska. Keeping these designations current and making sure that they align with your will and trust already, so you don't accidentally disinherit someone, is really important. So when you're thinking of the whole spectrum, the wills, the trusts, and then the non-probate transfers, you want to make sure all of this stuff aligns and there's not one thing that's in conflict with another, because then that's just going to create more issues during the probate process. So Nebraska probate now, the basics. Nebraska probate can be informal, it can be formal, supervised or unsupervised, really depending on the complexity and family dynamics. Essentially, your personal representative will gather assets, pay off legitimate debts that exist, and then distribute what remains to the family based on what's listed in your will. Small estates may qualify for simplified procedures if it's under a current threshold. Here, good records and a self-proved will is going to make this a lot faster and a lot cheaper for folks. And I mean, you want to keep it process focused, and we'll go over those thresholds again. But planning isn't only about death in this situation as well. It's also about incapacity for folks, and that will go into kind of the next slide here. So,
Yeah, switch up my.
oh. Okay, next, financial power of attorney. So financial power of attorney, this lets you appoint an agent to handle your finances if you can't or you're unable to. The Nebraska's Uniform Power Agency Acts govern these. You can make a POA effective immediately or only upon incapacity. Durable language means it survives during incapacity, or after it rather. These need to be signed to get notarized, and banks are happier, and you avoid guardianships when you do these. And I will just say a guardianship is very complex. It can be very, very fraught with like emotions and just issues with how those run. So if you want to avoid that, power of attorney can be pretty effective in sidestepping that process. Healthcare, power of attorney, and living wills. What are these? So healthcare power of attorney, basically the same thing as the financial one, but instead of making financial decisions, you're going to be making medical decisions on your behalf. A living will, this is related to POA, but it's different because this instead states, end of life wishes. So I see it recommended to have these posted sometimes like on your fridge door. So in an instance where you're incapacitated, suffer, like a stroke or something horrific like that, you can have instructions like "Do not resuscitate," "Do not try to revive me," or you can put, "Please, take me to the hospital, try to save my life at all costs." Just really depends on what you want in that situation. Again, I recommend everybody prioritizing certainly having the living will, because they're very, very. They're easier to execute and draft and just have posted and ready. The execution for that, you usually just need 2 adult witnesses or a notary. Would have to check the statutes on that. You can also include a HIPAA authorization so agents can access records. HIPAA, just real quick, is a federal law for privacy for your medical records. There's waivers that allow other folks to access those on your behalf. So this is something like really you want to discuss with your agents and your family. If you feel comfortable doing that, don't know necessarily your situation, and then you can revisit this over time and update it as necessary. Okay, choosing your fiduciaries, and this is very important as well. Okay, so when you're trying to choose your fiduciary, and obviously you want your personal representative for your will to be organized, someone who can be fair, who's communicative, who's not sketchy in any means. But honestly, like having the fiduciary on lockdown for the trustee, someone that you can trust, someone that is there for the right purposes, someone who's maybe just completely unbiased and disinterested in how things are being distributed. Those are all things to consider when you're trying to determine who's going to fill that role. And again, I think probably it says organize up there, but just having someone that has the capability of just knowing what deadlines are, and having things on their calendar when they know for sure they have to submit certain documents or reports to the court. That, in my experience, has been the thing that's gotten so many, trustees and trusts, beneficiaries just all mixed up in a lot of issues. The Yeah, if you want co-fiduciaries as well, consider, tie breaking mechanisms to avoid stalemates in those types of decisions. And again, having a qualified attorney helping you draft those safeguards into it is really, really important because, eventually these two people are going to disagree about something, especially something as sensitive as family assets. So if that's the route you want to go, just make sure you have that drafted well. Next slide. Planning for minors and special needs beneficiaries. So for minors and guardians, or excuse me, for minors, you want to nominate guardians in your will and use trusts so children don't receive large sums at 19. For special needs beneficiaries, consider a supplemental needs trust. This will help preserve benefits while improving quality of life. And then again, make sure you align all the beneficiary forms so money doesn't accidentally disqualify them from another document. Business, farm, and real estate considerations. So if you own a business or a farm, your estate plan needs to sync with your operating or buy-sell agreements. For farmland and multi-generation operations, you need to think through specifically who's going to manage, who's going to own, and how to treat off-farm heirs fairly. Property in multiple states is also a strong reason to use. Well, in this instance, you can use revocable or irrevocable trusts to avoid multiple probates. Some common pitfalls to avoid. Outdated beneficiary designations, make sure the assets are going to the right people. I mean, that's a pretty important one. Failing to fund your revocable trust, leaving any assets outside the trust. So that's why it's important to periodically go through and review these documents. Sometimes people do it as often as once a year, sometimes every 6 months, just really depends on their situation. Not having any sort of backups, skipping formalities, not having the correct executed documents, not having the right affidavits, not having the correct amount of witnesses on signing these paperwork. These are all things that could be flagged later on during the probate process and slow everything down. And also, and this is a new thing as well. Digital assets, so think like Bitcoin or other cryptocurrencies, even things like passwords for your accounts to your 401k, your other retirement accounts, and as well as passwords, of course. The quick checklist here. So with number one, with documents. A will is a self-proving affidavit, irrevocable trust if appropriate, and a funding plan, financial power of attorney, healthcare power of attorney, living will, HIPAA release, non-probate forms. This is the transfer on death for your bank accounts, your other retirement accounts, and then making sure you have the right people lined up, your personal representative, who the trustee or trustee is going to be, agents, guardians, plus alternatives in case there's incapacity or for whatever reason, the people on your starting lineup, have to be removed. And also, having these honest and really difficult conversations with your family, sometimes your friends, and making sure you have multiple copies of all these things and it's stored in a safe place. Could be on your computer, but if you need physical copies, keep it in your filing cabinet, keep it in a security lockbox if you have one of those. Making sure that in the event like a catastrophic computer failure, your hard drive is gone, all of a sudden you don't have these documents. It's best to hold on to the original, of course, but making sure you have these other copies in place to avoid something catastrophic like that. These are the statutes I referenced, where if you're interested in just reading some of these requirements, you can go here and see specifically. And they do a pretty good job of just breaking down like what the specific requirements are for holographic wills, regular wills, what the requirements are for the power of attorney, what needs to be on the form signed there. Let's go. Okay, next step here. So what you should be doing is getting a concrete inventory of your assets, your property together. Start thinking about your beneficiary designations, clarify the goals that you want with yourself, your spouse, your family. Selecting your fiduciaries and discussing your wishes with them. And then, engage with an attorney, highly recommended to draft Nebraska compliant documents and then properly execute them. That's, might seem like a no-brainer, but that step is often ignored by people, and that creates huge problems. And then continuously review these documents. Up here is 2 to 3 years, but if you do it every year, I think you're well ahead of the game and doing a lot better job than most other people, including yourself, for these things. And of course, the disclaimer that this presentation is for education only, not legal advice. But if you want to engage with Matt to get some of this stuff together, he'll treat you right. And that is what I got for you. Are there any specific questions before I hand it off? Cool. Thank you. Thank you.
Well, a few moments of transition here. Maybe I can just say click as we go. Say click. And I'm Matt McKeever. I'm originally from Norfolk and grew up in Norfolk. I'm the son of Ron and Donnie McKeever, longtime Methodists up there. Was confirmed in the Norfolk United Methodist Church. And now I'm at Elkhorn Hills. Yes, yeah. 9 o'clock service, find Lyle. I'm 12 feet to the back and left of Lyle. So Lyle, kind of the basis for finding them. That's a good way. So I'm an attorney. I've been practicing for 28 years. I'm licensed in Nebraska and New York. I have an undergrad here in Nebraska. I went to law school at Brooklyn Law School in New York. I had a good sense to come home. For most of the last 28 years, I've been doing a number of things, including estate and business planning, as well as estate and business litigation. So when plans are made, I like learning how to make the plans and making them well. Oftentimes plans break down. And so there needs to be some resolution. So I've been getting a lot of business, unfortunately, over the years for resolving estate plans that didn't quite work out. So here, we don't have a whole bunch of time. So again, I'd say, go ahead and request copies to be either emailed to you or my office can mail copies of these materials. And they are meant to be kind of just gone over generally so that you can go over the details yourself. And I'm going to cover the highlights right now and go over questions you might have. So essentially, the points that I want to leave you with are whatever your passion is for giving, like one of our speakers has said, whatever plan you want to make, there is a tool, there is a resource to do it. The law is flexible enough that maybe a will won't do it, a simple will won't get your plan done, but a trust might. Or maybe just having a resource like the Nebraska United Methodist Foundation, who can provide a trustee and administration and skilled planning services for you. Whatever it is you have in mind, it can be done. People have set up trusts for their pets. People can set up trusts so that they can donate farm ground, but the income goes to their kids. And they get tax benefits that way, or reverse. They give the farm ground to the kids, but in the meantime, the income goes to the charity or to the church. So you name it, there's probably a tool for that. And the other thing I probably want to leave you with is always ask questions. Our first speaker, I don't think he knew the chapter and verse, but it's something that I've lived by a long time, even before I knew it was in the book of James. Book of James, chapter 4, verse 2 through 3. If you do not ask, you will not receive. And I've usually told that to clients in the midst of advocating for them, in that go ahead and ask, because it usually doesn't hurt to ask. So always ask, because it doesn't usually, sometimes it does hurt to ask. And I think the verse actually says, unless you don't ask in the right way, or you're asking for something wrong. So long as you ask politely and you're doing the right thing, it'll work. Whereas I've learned if you don't make the judge angry, it should be fine. Not that I've made too many judges angry, but. And another thing too, and it's already been said today, involve the kiddos. If someone's doing an estate plan, let the kiddos know generally what they don't need to know exact things. You might want to keep things private, but generally let them know what your plan is. And if you are giving something substantial to a charity or some other organization, whatever you want to do, it is best to keep them involved and know that they will know things are fair. And like I said, I've done a lot of litigation over the years. And litigation is avoided when there's a plan and everyone kind of generally understands what the plan is, what mom and dad wanted to do. So always also involve an accountant, a financial advisor, and either a lawyer or something like the Nebraska United Methodist Foundation, because they can help you with the services you need to get your plan done. And part of planning involves a bob. I hadn't called it a bob before today, but that bob is a great idea, and I took notes and I got all 14 tabs down. And I usually have a questionnaire that's very detailed, like where is your safe deposit box? What are the account numbers? If you have any digital assets, where are they? And that's a very big part of planning, of course. So definitely recommend a bob as well. So let's go to the materials. That's me. I've got two slideshows here. One is about generally the flexibility of trusts, and other about charitable planning in general. So generally you can do a simple will. A revocable transfer and death deed is also a tool you can use in addition to a simple will, which just says, I own my house, but when I pass away, my house goes to these people. And therefore you don't need a will for that. It becomes what's called a non-probate asset. If you need a will to transfer it, it's a probate asset. If it transfers without a will, it's a non-probate asset. That saves some time and expense in the probate process in court. Click. Revocable trust, we've covered that a little bit, but that basically means you've made a trust, you still control it as far as the government and the IRS are concerned. It's still part of your taxable estate. So let's go click. For revocable trusts, we talked about that, but for irrevocable trust, then it's no longer part of your estate. You don't control it. Oftentimes, that's where you get the tax benefit of giving something away in the irrevocable trust. And the IRS doesn't consider it part of your estate. But there are a number of things you want to discuss and consider in making a will or a trust, because sometimes you don't need a trust. And a lot of times there's an Omaha World Herald article from about 10 years ago. 3 experienced estate planners were asked, do you need a trust? And most of the time you don't. If you have some plans and you need to do some special work, that's where a trust might come in. But you need to know things like how many beneficiaries do you have? Do they get along? What other special considerations you need? You have someone who has special needs, where a special needs trust can be used to help someone who's disabled and might be relying on public assistance, and you don't want to jeopardize the public assistance. Who do you want as a trustee? And do they have the capacity and expertise to be a trustee of your trust? Or maybe you want to use an institution like a bank trust department or Nebraska United Methodist Foundation as their trustee. It's a very valuable resource because they don't charge a fee, and the bank will charge a couple percent.
We don't act as trustee.
Oh, you don't act as trustee, but you will administer the trust.
Yes.
Yes.
If they need a trustee, we refer them out to Union Bank and Trust.
That's a good place. That's right. They're across the street from my office in Omaha. So yeah, I'm familiar with their trust department. Let's go on to the next click. So here are some considerations if you're considering a revocable trust in addition to a will. And again, a revocable trust means you can change it while you're alive at any time. It usually becomes irrevocable when you can't change it anymore, i.e. you have passed and you can't immediately change it. So these are just some considerations. They'll be in the materials. For example, if you want some flexibility about who's in charge, the trust is more flexible too. You can set up a trust in your will as well. And one of the advantages of trust is that it continues after your will. Your will basically has to be administered, everything distributed in a year or so. They don't usually last too much longer than that, the estate. But a trust can theoretically last almost forever if it's charitable. And if it's a trust that you set up for kids, for example, it does have a lifespan of 99 years plus the life of someone living now. So there is a limit to how long a trust can last, unless it's a charitable trust. You click. You can do a will that includes a revocable trust for minors, because until the kiddos turn 19, they technically can't own property. So you can designate a trustee, oftentimes their parents, to administer their assets. And there's not much in the way of cost to do that. That's usually involved with part of it. But let's just go on to the next one. Real estate, if you have a trust, you title then the real estate, like your house, in the name of the trust. So it passes along as soon as both husband and wife have passed away. When the last person passes, then the house automatically transfers instead of having to wait through the probate process. You don't have to do that, but it is very useful. And there might be other considerations that a trust can cover, like mineral rights to farm ground or something like that. I'm going to go ahead and click. There are beneficiary designated assets. We've talked a little bit about those, the IRAs and the Secure Act. I won't cover that too much more, except with the Secure Act, it is extremely important to designate your beneficiaries. We've talked about the minimum required distribution, doing that for charity, and the benefits of that. But it's extremely important because of the rules of how IRAs can be received through an inheritance. That if you don't designate who the beneficiaries are, there are some complicated rules that essentially add up to a lot of taxes if you don't designate your beneficiary. So make sure you talk with your plan administrator saying, hey, does my 401k or does my pension, does my IRA have a designated beneficiary when I pass? Does it have an alternate? You want to make sure that you have someone designated. So that's for Roths, it's for annuities, it's for everything. So I have a summary here from the Secure Act for beneficiaries. It's been covered a little bit today already, but that'll be in the materials. Again, you have non-spouse beneficiaries have 10 years to withdraw the inherited IRA, like we talked about. That might mean that they have 10 years of extra income that bumps them up into an extra tax bracket. And suddenly what was going to be an inherited IRA is now being, a lot of it's going to the federal and state government. Let's go on to the next one. Roth IRAs are really good. Again, probably don't need to cover too much ground with that. Let's go on to the next one. Annuities, I don't usually favor annuities. Some financial planners can make them work. So that depends on you, but they have their own special rules. They are summarized here, but basically you're getting a stream of income and it's guaranteed. And sometimes that's a benefit to you. You have to talk with your advisor about that. Let's go on to the next one. Life insurance is a very useful tool. You can use it for trusts. You can have an irrevocable life insurance trust, and it could be a charitable irrevocable life insurance trust. So you can have payments that are tax deductible, for example, and then the life insurance distributes the beneficiary as the church, for example, or an endowment. So life insurance, of course, very useful. There are trusts where you do premium payments and there's a cash value, and it's possible that the cash value will be more than the death benefit, and whoever the beneficiary is could benefit from that. You can also divide beneficiaries and say, my kids get half, the church gets half. Whatever you want to do, it's very flexible. We'll go to the next one. Depository accounts, again, make sure the tax consequences aren't quite as harsh for a depository account, but you want to make sure all your accounts have a payable on death provision. So talk with your bank about that. Same with brokerage accounts. Make sure there's a transfer on death designation, or the account could be in the name of your trust, and that might make it pretty easy to transfer. Go ahead and go to the next one. Click. Business interest can also be passed by provisions like if you have an LLC that owns farm ground, if you own a business or you're a partner in a business, your operating agreements, your partnership agreements, your bylaws of your corporation should all have provisions. What happens when you pass? There are pretty standard provisions for all of those. So on the next. Cars, boats, and airplanes. You can jointly title most of them, and that's usually the easiest way to go. And if you have all your assets in a trust or have otherwise been able to give them away without a will, then your probate estate, what they call what's needed to be probated by a court, might wind up being less than $100,000. There have been estates that overall, they were big, they were taxed for $2 million. But the assets actually going through probate were less than $100,000. If that's the case, you don't need to put your will into court. You might need to ask the court to determine what your state inheritance taxes are. But you don't need to go to court. You can write what's called a small estate affidavit. It's a one-page document. You sign it in front of a notary saying, I'm the next of kin. These assets were less than $100,000. They should go to the following people. And that's it. And it has to comply with the will too. But that makes it a lot less expensive than spending $5,000 on. Yeah.
Is there a difference on a vehicle title, tax wise, whether it's the TOD or the joint ownership?
It doesn't make too much of a difference actually for purposes of, and what we'd be looking at is Nebraska or federal for that matter, inheritance tax, because so long as you own it, whether jointly or individual, whether it be a car or truck or boat or bank account or inheritance or IRA, whatever it is, if you own it, it's part of what's called your gross estate. So even if it's not transferring through a will or you jointly owned it, it's still counted as yours for tax purposes. So it might be a joint account. You think, well, wouldn't that be 50-50? No, for a joint account, both people own the whole thing.
Right.
So you get taxed on it. I think, is that the end? Do we have anything more to click? That's us. That's the team. We have 7 estate planners out of the 11 lawyers. So we can, there's my smiling face there. Let's go on to the next one. I think I've got 10 minutes left, or maybe a little less, so we'll zip through this one too. About 5. Okay, I can do this. We want to have some time for questions and answers too. And these materials also have the tax thresholds, the gift exemptions that you can do a year, which are $19,000 per individual, or $38,000 for a couple now. And then there are also new total amounts that you can give in a lifetime, your lifetime exemptions. So let's click. There's an outline. So when you're reading through these materials, this is kind of the guide. There are many advantages to charitable giving. That's the gist of this slide, is how it is very advantageous to give in a plan for charities. There are a number of tax advantages in addition to supporting your passions, as we've discussed, and how flexible that is to support your passions, because we can create a tool to do just about anything you want to do. You get a lot of tax benefits. So first of all, you have to make sure that the charity, if it's church, it's certainly a 501c3. The Methodist Foundation is a 501c3. And there are limits to how much you can donate, of course. We've talked about those a little bit. Let's go and click on the next one. For deductions, you have a standard deduction. I think that has changed even. I need to change that for the big beautiful bill. I think
15,000.
it's 15,000.
And 30,000.
Yeah, and 30, 31, 16. Anyway, you can, one strategy is to bunch donations, like giving a donation, either on December 31st, another January 1st, or vice versa, so that you're doing one donation that's split up over 2 days, and you get the benefits of both years. There are a number of strategies for tax benefits. Capital gains, again, has already been discussed a little bit. The idea here is don't cash out your stocks and then give it to the church. Give the stocks to the church. The foundation can be a great vehicle for that. So, and sometimes there are specialized assets that might need some help, and the foundation can help with that. There might even be digital assets like Bitcoin. There are a lot of Bitcoin millionaires in Nebraska actually right now, and some of them want to give, but whoever receives it has to be able to have the means to give it. So the whoever the charity is, they need to basically have an account and receive the Bitcoin directly from the donor to get the tax benefits. There are a lot of types of donations that need that kind of special help. The foundation can help that. Click. Inheritance taxes recently changed in Nebraska. For we'll talk about federal, but for Nebraska, it taxes 1% after the first 100,000 to your kids, your next of kin, your close relatives. 1% after deductions. They're usually deductions for the expenses of the estate. distant relatives, which means, cousins, uncles, aunts, they have to pay 11% of what they receive after the first 40,000. And everyone else is 15% after the first 25,000. So that could be really expensive in Nebraska. Charitable organizations, of course, there's no tax. So anything you leave to a charitable organization, no tax. That $100,000 deduction is per person. It's not your total. So each person you give it to, that's if you have 10 kiddos, you get $100,000 exemptions, one for each kid. Here are the federal estate tax deductions, and they are going to be, right now it's $13.99 million for a lifetime total exemption, is basically what it is. The big beautiful bill changed that to 15 million in 2026, and that will stay that way. It's not going to change from year to year until Congress changes its mind and changes it. So portability is still in effect, which means each spouse has $15 million of exemptions over their lifetime for taxes. So if someone passes away, they were married, up to a $30 million estate can pass without federal inheritance taxes. If that's a problem, let me know. It's a great problem to have, but hopefully
There's my answer.
it's going to flip. Gift taxes, we talked about briefly. You get a gift tax exclusion annually of $19,000. That does go towards your lifetime exemption, which again will be $15 million per person next year. You can give up to $19,000 per person per year. So if you have 4 kiddos and you're married, you can give each one $38,000 and not have any gift taxes to worry about. If you do, whether it's under or over the $19,000, talk with an accountant to make sure you get a gift tax. There's a form that they file with the IRS to make sure that you track what you have given, and that's a benefit to you.
Are minor grandchildren another person, or they land under the parents' exclusion for gifts?
It's per person, so you could give $19,000 to a parent and
Gotcha.
19,000 to kiddos. If you have grandkiddos, 19,000 to each grandkiddo.
And back on
Big
the
family,
state,
right?
back on the state piece, are grandchildren considered the immediate relatives? Or do they fall in that category of the more distant relative?
They are immediate, they're direct descendants. of-
Okay,
so
gotcha.
they are-
Thank you.
Good question, yes. Let's go click. Gifts of money, anytime you give any money, just keep some sort of receipt for $250 or more, put it in your bob. And you can give non-cash items, of course, just make sure you know what the fair market value is at the time you give it. Let's go on the next click. You can do a request in a will and trust. You can have trust provisions for the gift. And I have some sample language in there. I just put up Camp Fontenelle because I'm a fan of Camp Fontenelle, and Foundation because I'm a fan of Foundation books. Let's go click. You can donate through wills in a bunch of ways. I have some more examples here. Go ahead and click. Charitable trusts. These materials go over the various types of charitable trusts you can make for donations that last theoretically forever, or donations that happen immediately, but your family might get some benefits in the meantime. Whatever you want to do, there's a charitable trust. There's, and again, charitable trusts at the bottom here can potentially last forever. There's a rule against perpetuity, so that it's 21 years after the life of someone living now. That's the limit of time that a regular trust that's not charitable can last. Otherwise, it ends after 21 years in the life of someone living right. You want to go on to the next one. And I think before I go into, we'll probably click rapidly after this one, but trust need trustees. The trustee does need to know if it's a family member, someone you love, know, and trust. They need to know all their responsibilities. For example, there's mandatory at least annual reporting that they need to distribute to all the beneficiaries of the trust. And the estate litigation I've done recently has always been stepmom or someone else being a private trustee to save money, but inevitably they don't know how to do the trust or comply with the law for trustees, and it winds up being a lot better if they had just some professional doing it. Most sometimes it's a lawyer, very rarely it's a lawyer. Usually you see a trust department. So let's click rather rapidly. I have some examples of charitable trusts here. Click, keep on clicking. So you get charitable remainder trusts where there's a remainder. You can donate now. You can donate the property now and get the income until you pass, or you can donate the income and keep the property now. So there are different types of charitable trusts for that. Keep on clicking. There's some examples and some diagrams, because I love pictures. And yep, there are all sorts of different examples of charitable trusts. So let me know if you have any questions. Again, the PowerPoints, the outlines for both the attorneys that are presenting can be emailed to you, and I can just regular mail them to you. Or again, if you want to go to Elkhorn Hills United Methodist Church, look for Lyle, 12 feet behind him to the left, the church.